Welcome everyone, and thank you for coming to this extraordinary event. It is my great pleasure to introduce to you today's speakers, Mr. Pedro Martinez-Fraga and Mr. Reetz, who are among the finest arbitration practitioners today out there. Let me put it this way. On Sunday, Tom Brady again led the Patriots to victory. And while in the field of international arbitration there is more than one Brady, and two of them are with us here today. Mr. Martinez-Fraga is a partner at Brian Cave Miami office and a co-leader of the firm's international arbitration team. Graduate of St. John's College and Cornell Law School, he received his PhD from the University of Madrid. He acted as an arbitrator in many ICSID and ICC cases and as counsel in proceedings before most of the major arbitration institutions. In addition, he also maintains an active international human rights practice. And in 2015, President Barack Obama appointed Mr. Martinez-Fraga as one of 4 US delegate members to the ICSID panel of conciliators. He also serves on the advisory council to the third restatement of the law of the American Law Institute, and is a prolific writer, having published in 15 countries and in 5 languages, and written more than 50 articles and 6 books on private and public procedural international law. Mr. Martinez-Fraga is also a recognized figure in the academia, having lectured in more than 30 universities globally, and he currently serves as an adjunct professor at the New York University School of Law and as a visiting professor of international litigation and arbitration at the University of Navarra School of Law in Pamplona, Spain. Previously, he served as an adjunct professor at the Miami Law School. Let me now turn to Mr. Reetz, who is a co-founder and office managing partner of Brian Cave Miami office. A graduate of Harvard College and Boston University School of Law, Mr. Reetz maintains a large commercial litigation and international arbitration practice. He acts as a trial counsel in international and domestic commercial and regulatory disputes, class actions, complex litigation, and regulatory matters. In addition, he is regularly appointed as an arbitrator in domestic and international proceedings. Mr. Reetz currently serves as the chair of the Miami International Arbitration Society and is an active member of numerous professional organizations, including the American Law Institutes, where he serves on member consultative groups for the third and fourth restatement of the law. He has lectured at various universities and institutions, including the Swiss Arbitration Academy, and was a scholar in residence at the New York University School of Law in 2015. Similarly to Mr. Martinez-Fraga, he currently teaches transnational civil litigation and arbitration at the University of Pamplona and taught the same subject over many years at the Miami School of Law. Before I give the floor to the speakers, allow me just to add a few words on the topic of this presentation, which is the same as the title of the brilliant book written by the speakers, and which was published in 2015 by Cambridge University Press. As we often witness on a daily basis, economic globalization has changed common understanding about sovereignty and interaction between public and private entities. And in the field of international investment law, the often conflicting legitimate rights of the state to regulate, and its equally undisputable and binding obligations towards foreign investors usually rests on the scope and application of the very elusive yet ubiquitous notion of public purpose. At the same time, I think it is fair to say that the little attention devoted to this notion in the doctrine is disproportional to its significance, and the authors should be highly applauded for their efforts to address this doctrinal void. So, without further ado, please join me in welcoming Mr. Pedro Martinez-Fraga and Mr. Brian Reetz.
Thank you, Chick, for that very kind and generous introduction, and for the very kind and generous invitation to be here to speak with all of you. We're very, very happy to be here. In talking about public purpose, I think it's a fair question to ask whether there's really anything to discuss, whether there's room for different views on the subject. And in thinking about that question, I think it's helpful to think back to an old joke from the 80s in the Soviet era. And in the joke, a man pulls up his car and parks right in front of the Kremlin. And a militiaman comes up and says, "Are you crazy? You can't park there. The whole government's in there." And the man says, don't worry. I have excellent locks on my car." And what does the joke tell us? It tells us that people have different perspectives on the use of state power. And it's for that reason, really, that we thought this was an interesting doctrine to discuss in that context. What is public purpose? With so many of you interested in international law, it's important to point out that public purpose is not the same thing as public policy or ordre public. The latter has a wide range of application, but we usually see that public policy is a question of what the state will permit. Will the state permit parties to engage in certain contractual behavior? Or will it lend its power to enforce an arbitration award or a judgment from somewhere else? In contrast, the notion of public purpose is really focused on the proper objects of state action. Where do we see public purpose in the law? We see it in several aspects of international law, not simply one. We see it in international human rights law. We see it in the law concerning permanent sovereignty over natural resources. And of course, the area where we see it that's most familiar to us and relevant to our practice is in international investor-state law, or investment protection law. Within that field, where do we encounter public purpose? We see it in two different aspects of investor-state protection law. We see it in terms of sources of law. We see it both in terms of investment protection treaties and in customary international law. And we see it having two places within the investor-state area. First of all, we see public purpose in the law on expropriation of property of foreign nationals. And multiple sources of law, including bilateral investment treaties, multilateral investment treaties, investment protection agreements, and even customary international law, say that a state may not expropriate the property of a foreign national unless four conditions are met. The expropriation has to be for a public purpose, it has to be non-discriminatory, it has to be involving some form of due process, and it has to be against some form of compensation, usually phrased as prompt, adequate, and effective compensation. But one of those four things that you have to have in order for a state to be allowed to expropriate a foreign national's policy is that first element, the requirement that the expropriation be for a public purpose. So that's one of the places we see it discussed in the investor-state field. The second place where we see public purpose referenced in the investor-state field is in deciding whether regulatory activity by the state constitutes an indirect expropriation. In other words, the state isn't taking over formal ownership of the property, it isn't taking title to the investment, but it is regulating the investment in such a way that it's depriving the owners of most or all of the economic benefit of the investment. And how is public purpose relevant to that question of whether a regulation is an indirect expropriation? Well, there's a lot of disagreement in the field, but there are some authorities that say that where a state regulates according to principles of due process and for a public purpose, that regulation is not going to be an expropriation, that it's simply the state acting in its regulatory capacity. And you have to look to some other doctrine of investor-state law to protect the investment. So those are the two places in the field where we see this concept of public purpose. Is it defined? We see that in the treaties, the bilateral investment treaties, public purpose is not defined. None of them say what constitutes a public purpose. And almost no other source discusses the idea in any detail. There are a few fleeting references in some of the national legislation that protects foreign investment, foreign investor protection statutes that talk about what's a public purpose, but they're in such a limited context that it's really hard to draw general principles from. So we have a doctrine that isn't defined by any of the modern instruments and is not discussed in any detail. There is a general historical view in terms of what public purpose is, and we'll talk about that in more detail. But that general historical view is that a public purpose is whatever the state deems to be for its own ends. In other words, if the state says that its action is for a public purpose, it's for a public purpose. The state has the final word on that question. What are the consequences of whether an whether a state action is for a public purpose? Well, you may remember that I mentioned two parts of investor state protection law where public purpose appears, and each of them has a consequence. In the question of whether a state has expropriated property legally, the four-part test that I mentioned, if a taking is not for a public purpose, then that is an illegal expropriation. And there is a long line of authority going back to the, the Chorzo factory case before the International Court of Justice in the 20s that says that for an illegal taking, the damages that you get, the compensation that you get is a higher level. It is a full compensation of all losses suffered rather than simply adequate compensation. So if a taking is not for a public purpose, putting this in terms for American trial lawyers, you get more damages, or at least the possibility of more damages. The second consequence that we see of the public purpose doctrine in investor state law is this idea of whether you have an indirect expropriation. If the state regulates and the regulation is found not to be for a public purpose, then all of those authorities that shelter regulations against becoming indirect expropriations, those authorities don't apply because they are conditioned and premised on the idea that the regulation is for a public purpose. In both of these contexts, whether an expropriation is deemed to be illegal or whether a regulation is deemed to be an expropriation, we see that the idea of public purpose is a way of mediating or moderating tension between two duties that the state has. And they're duties that Mathieu mentioned in his introduction. The state has a duty to regulate, a duty to make law for the benefit of its citizens. But it also has a duty to protect the property of foreign nationals. And in both of these senses, where I talk about public purpose hearing, it's a way of accommodating some of the tension between those two duties that are so often in conflict. So you've heard the historical view of public purpose. You've heard that it has two consequences in investor state law. Is there really anything to discuss? Or can you go home now and go to your next appointments now? We think there is something to discuss because given the very broad definition of public purpose, those two consequences that I mentioned will never, ever come into play if we accept that definition. If the state has the final word on whether something is for a public purpose, the state will always say, our actions were taken for a public purpose. And so you'll never have an illegal expropriation based on the absence of a public purpose, because the state said it was for a public purpose. And you'll never have an indirect expropriation based on the absence of a public purpose, because the state has the final word. And this tension or paradox is recognized in the comments to the Restatement Third of the Foreign Relations Law of the U.S., which basically say, and I'm paraphrasing here rather than reading it to you, but the doctrine hasn't found much purchase in decisions because if the state has the last word on what's a public purpose, you can't effectively re-examine that. And so the doctrine really hasn't played much of a role. And so this very broad definition of a concept that in theory is supposed to have important legal consequences leads us to a choice. We can either accept that the concept of public purpose is essentially meaningless, and that the language in the international instruments, the bilateral treaties and the like, that talks about public purpose being a requirement is essentially meaningless, because it's a test that will always be met because the state has the final word on whether its action is for a public purpose. Or we can try to arrive at a deeper and different understanding of the doctrine to see if there's some way to give that language meaning other than whatever the state says, and to see whether the doctrine in its current form or in the form that it may take on adequately addresses the needs of the international system. And when you think about the international system, it's one that has changed. If we go back 300, 400 years, you have a notion of the state that's very much based in territorial sovereignty. It's the old Westphalian notion of sovereignty, where the state is the absolute master of everything that happens within its borders and has no authority to speak to anything that happens outside its borders. Well, that was fine at one point in history, but with the advent and really rapidly increasing pace of globalization, we've moved from a system of sovereign independence to one of sovereign interdependence, where the rights and obligations of states are in flux, and states need to be able to take greater account of what's happening outside their borders and show greater restraint in acting within their borders. So in other words, although this doctrine of public purpose is historically viewed as self-judging and entirely up to the state, is that really appropriate in the modern world where states are highly interdependent? And with that question, Pedro and I decided to look into the doctrine from really three different perspectives. A historical perspective, how did the traditional view of public purpose develop? A descriptive doctrine, a descriptive perspective, excuse me, how is the doctrine applied? How can we see it reflected in different aspects of international law? And ultimately, a prescriptive perspective, what suggestions can we make for further development and understanding of the doctrine? And as I mentioned, we found that this is not an isolated concept in investment law, that you can draw understanding of public purpose from a number of places in international law. And in looking at it from this perspective, we have identified a number of suggestions that we think can take the doctrine further and make it more useful. And at the risk of sounding like a BuzzFeed headline, here's what happened next.
Thanks. I'm going to talk to you a little bit about the three approaches, but I'm going to take the three approaches out of order. In other words, I'm not going to talk about the historical approach first, and then the descriptive approach second, and then the prescriptive approach third. I'm going to talk to you about the descriptive approach now. And descriptive meaning, where do we stand on public purpose? Are we satisfied with what we have? What we have right now is an intuitive methodology for identifying public purpose, pursuant to which it is anything public as articulated by the state, without more. So it's a self-judging, subjective content that is not consequential in analysis. It doesn't go into, well, if we apply this and classify such a thing as a public purpose, or this measure or this regulatory activity as a public purpose, what are the consequences? We never get there with the status of public purpose today. Let me share with you what the restatement second of the U.S. law on foreign relations said about public purpose. Now this is important because this is back in 1965. This is the restatement second on the U.S. law on foreign relations. It says, quote, "There appears to be few, if any, cases in which a taking has been unlawful under international law on the sole and specific ground that it was not for a public purpose. There is little authority in international law establishing any useful criteria by which a state's own determination of public purpose can be questioned." End of citation. Notice that it talks about the state's own determination of public purpose. Now let's fast forward. This is the restatement third on the U.S. law on foreign relations. And even though this is a 1987 restatement, it goes all the way to the present because it's still the restatement that is in place. Here's what it says. And I quote, "The requirement that a taking be for a public purpose is reiterated in most formulations of the rules of international law on expropriation of property. That limitation, however, has not figured prominently in international claims practice, perhaps because the concept of public purpose is broad and not subject to effective re-examination by other states." End of citation. So, past and present, the restatement of the U.S. law on foreign relations says that public purpose cannot be reviewed. As a matter of law, as a matter of its own elements, it is not reviewable. Just one more source. This is a scholar, Nico Schreiber, writing on the subject of permanent sovereignty over natural resources. A very nice book, but he has to deal with public purpose, and in doing so, I want to share with you what he says about it. Quote, in most relevant arbitral decisions, the view has been taken that a lawful nationalization or expropriation must serve a public purpose, citations omitted, but sometimes with qualifications. For example, in the Liamco case, it was held, and this is a citation within the citation, as to the contention that the said measures were politically motivated and not in pursuance of a legitimate public purpose, it is the general opinion in international theory that public utility is not a necessary requirement for the legality of a nationalization. Shriver goes on to comment, while many conclude that the demand of a public interest or public purpose should be maintained, there is recognition of the fact that ultimately it is the taking government which determines the public purpose or utility. Listen to this. The taking government, the government that has expropriated a foreign investment, determines whether that act of self-enrichment is legitimate. It goes on to say, and in many cases, it can be taken as impossible that an international court or organization can form a reasonable judgment on the accuracy of a claim by a state that an action served a public purpose. In summary, if a state is not completely free to determine the justification and conditions for a nationalization, but it is bound by certain international law requirements. In practice, however, it has wide margins of discretion. So the question becomes, what is this public purpose? If it's nothing other than what the state says, do we just keep generating law and commentary that reiterates this notion? Let me explain what the real problem is when you read the two restatements together. When citation or mention is made of a state's own determination of public purpose and not subject to effective re-examination because of the elements. You see that what is really happening is that a mistake is being perpetuated. Let me explain. The dialogue or the problem is such that you, the reader, you, the subject or object, is being asked to accept an assumption. For example, when you're asked, is the glass half empty or half full? And you know what they say. Yeah, half of the people say, well, it's half empty, and then those are the pessimists, and it's half full, those are the optimists. But let me explain something. There's a trick in the question. The answer is, from a technical physical perspective, it's both. It's both half empty and it's both half full. Even though some say that if you were to ask an engineer, the engineer said, well, the problem is that the glass is half the size that it should be. But the bottom line is that the way the question is phrased invites you to accept it as a take it or leave it either or. And it's not an either or. The same thing happens with public purpose. Public purpose is not an intuitive concept. Public purpose is not and cannot be defined by whatever subjective, self-serving reasons a state may have. The next question becomes, how did we get here? And we tried to, right now, look back, and we started going back and back and back and back, and regrettably, or maybe not, we ended up with Homer. And the first references to public purpose in the context of a taking, of taking property for the benefit of a state, or in this case, a geopolitical subdivision, a city-state in ancient Greece, we found was in Homeric writings with respect to the taking of slaves. And we saw that the word there is demos, or demus, depending on the masculine or the feminine. And when you look at that word, the way it's used in the context of takings for the benefit of the state, it really means, not too loosely translated, as chatter or commodity with feet. So the public purpose doctrine in its origins says you are justified in engaging in the act of enslaving so long as it's for the public purpose of benefiting the state. Fast forward just a little bit, and in classical Greece, now mind you, this is the Greece of the great playwrights, of Euclid's elegant analytics, of Aristotle and of Plato. There the word becomes andropado, literally now very clearly, chattel or commodity or thinness with feet. And here we found multiple explicit references to public purpose as being so important that, again, it justifies a taking of a human being and the commodification of the human being. So we found that public purpose and its intuitive roots has two core elements, ladies and gentlemen: territoriality and language. The ancient Greeks were looking inside based on territoriality. And you see this, for example, in the word for foreigners. The word that is the etymological root for our word for barbarians, barbaros, which is really an onomatopoetic word for the way the Greeks heard, mostly the Athenians heard, particularly the Persians, and the Medes speak, you know. That's how their language sounded to them, they say. In its infinitival form, barbarizine, it's even worse. It's to speak gibberish. So you see how language, so everything that's that ancient Attic Greek, it's gibberish, so speaking of sounds. So territoriality and language combine to provide for this concept as being intuitive, and it's just what is in the state's best and greatest benefit. This became somewhat problematic because the concept of public purpose is so enshrined that it only found one exception. And the exception is in the word spondo, which really means en spondum ex spondum, which really means treaty or alliance. And it's very much tied to the words for libations or the drinking of wine, which in this campus or any college campus may be of interest. But the reason why it's tied to libations is because the Greeks, when they finished signing a treaty, they would pour libations or wine that they wouldn't drink to the gods. And the only exception pursuant to which you cannot justify a taking for a public purpose is if the subject, if the person, the would-be slave, is a citizen or a member of a city-state that has signed henspondo, a treaty with another city-state. But if you're ex-pondo, then you have a very, very serious problem. And that is the origin of this intuitive problem. We tried to understand how this public purpose played out, and we tried to develop a lab, if you will, for public purpose where it can actually be looked at, taken apart, and understood more closely, and maybe use that as a point of departure for developing an analytical model that would remove it from subjectivity, turn it into an objective standard that is recognizable, that it's not just what the state says, that is consequential in application, and that also comports with more than just a take it or leave it, all or nothing result. Something that embraces, a concept that would embrace the international notion of proportionality. We found this lab in something that you recognize very well, which is called the NAFTA Multilateral Treaty. It's still in effect, I don't know how much longer, but and the NAFTA became the natural and obvious petri dish for this experiment because of its very structure and configuration. You know, the NAFTA with seven parts, 8 annexes, 22 chapters, is very, very vast. It's very robust in its subject matter. It aspires to remove barriers, to increase competition, and create for a space for intellectual property rights and so forth. Similarly, it has a dispute resolution mechanism that has both substantive and procedural rights. So it has the entire anatomy of investment law, and it also international investment law, and it also has the anatomy of international commercial law, all in one treaty. We also thought that the NAFTA was very rich, because the NAFTA has a NAFTA, quote, jurisprudence. As you know, in investor-state arbitration, there really isn't a jurisprudence because arbitral awards are not binding. Plus, arbitrators are not judges. And they're impaneled after a problem arises. They will not be impaneled for that problem anymore, and it's not reviewable. So it's not the state exercising its sovereignty through courts. But you still have arbitral awards under the NAFTA. So this was very, very helpful to us in understanding that. More importantly, or equally importantly, we also have cases that are not NAFTA cases, but that historically are analyzed by commentators together with the, quote, NAFTA jurisprudence, such as the TechMed case, which is really an investor-state arbitration under the Spain-Mexico bilateral investment treaty. So the NAFTA also offered this wonderful feature. But the most incredible aspect of the NAFTA that also rendered it a very viable model of analysis for public purpose is that the NAFTA in 1101 subsection 4 actually does something quite remarkable, nowhere else to be found. It sets a standard for public purpose. It does not define public purpose. And you know, the word definition is define, to put finite, to render finite so that it's describable. No, it doesn't. The drafters of the NAFTA were sufficiently wise to know that that could not be done. But in 1101.4, they set a standard which I will share with you because it also will help you understand the scope of the problem and therefore the depth and breadth of possible solutions. In 1101.4, this is the way the standard reads. It says, quote, this chapter applies to measures adopted or maintained by a party relating to investors of another party, investors of another party in the territory of the party, and it goes on, but section 4 says, nothing in this chapter shall be construed to prevent a party from providing a service or performing a function such as, and these are the two most important words in this standard, such as law enforcement, correctional services, income security or insurance, social security or insurance, social welfare, public education, public training, health, and child care, in a manner that is not inconsistent with this chapter. If you break down what I just read very quickly, you'll see that it's hard to imagine, even for the most gifted imagination, anything, any type of activity within the space of a state that's not covered by that, or something that's derivative. But notice that it's not purporting to be exhaustive. It says such as, and it says that if something is inconsistent with any of these, then the state can act. So it provides the state with a lot of power. Let me just share something with you that's not in the NAFTA, but it's in the NAFTA working papers. As you know, the NAFTA has three parties, right? The United States, Mexico, and Canada. Of these three parties, the capital exporting state, the industrialized state, obviously is the United States, with a close second in Canada. And the state that would likely be a host state, a capital importing state, not a capital exporting state, would be Mexico. Okay? Keep that in mind. Now, the U.S. wanted to put in this provision with respect to public purpose. Now remember, if I said that the U.S. is the capital exporting state, that means that the U.S. is going to have the investors who are going to invest and who are the most likely people or group of entities that will be wronged by takings by the host state. The host state can engage in takings by using the public purpose doctrine. Here's what the U.S. wanted to put into the NAFTA rather than what I just read to you. It says, quote, the term public policy does not include the deliberate disadvantaging of investors of another party or country, close quote. The United States saw that through public purpose, it was very easy, even within the NAFTA framework, to be able to engage in regulatory sovereignty that would be tantamount to a taking and diminish greatly and materially the value of an investment. That language did not make it into the NAFTA. Now, when we saw all this, and the NAFTA goes on to do two things. It sets forth, also in Chapter 11, 15 additional examples of public purposes. In other words, encompassing every possible aspect of what a state could do, so that it's extremely broad and expansive. Virtually anything could be public purpose and the reader is challenged to identify something that would not be. When we looked at the case law in the NAFTA, and we talked a lot about two cases, Metalclad and Methanex, those are two polar extreme cases. In one case, the tribunal applied an effects test. It did not at all take into consideration public purpose. In that case, the state was precluded under that award from engaging in very legitimate regulatory sovereignty having to do with the management of a waste hazardous station. So it was the environmental regulatory expression of the state was curtailed with no analysis whatsoever on public purpose. Only an effects test was applied, pursuant to which the effects of the regulatory measure on the investment was considered. And of course, viewed from that point of view, through that prism, through those lenses, of course there's going to be something very wrong. It's being decontextualized. The other case is Methanex. And in Methanex, of course, it's the opposite extreme. Public purpose is applied without real analysis of proportionality, without real analysis of effects, and only based on fundamentally one study. And it's very clear that the reader, the jurist, the commentator, the practitioner is left with no guidance whatsoever, because there's no standard for applying public purpose. There's no standard for having a test under the NAFTA. So the NAFTA jurisprudence, to call it that, was for purposes of helping us very, very disappointing, as was the actual text of the NAFTA. So where did we leave off, and what did we see? We see that the NAFTA had no hierarchy in terms of public purpose. It had no standard for public purpose. And in fact, the NAFTA jurisprudence did violence to public purpose when it started adopting an effects test, which was an effect taken from another provision of the NAFTA, 1110, paragraph 1, subsection A, which is the expropriation language and the expropriation provision, which talks about effects, but has no guidance on how at all to apply it. Public purpose, ladies and gentlemen, is more than just something that applies in international investment law or international trade law. It is critical to human rights law. In fact, if you look at the three principal human rights conventions, the European Convention, the American Convention, and the African Charter of Human and People's Rights, you will note that public purpose is critical to each and every one of those. And even more so that the courts, the European Court of Human Rights, for example, in my opinion, has gotten it wrong each time it has relied upon public purpose for an adjudication. The application of the legacy public purpose doctrine, the application of a public purpose doctrine that is completely subjective in content and self-judging by the state, has led the European Court of Human Rights to make errors, commit errors that are fundamental and against, for example, religious freedom in the Said versus Turkey case. And the Perugia versus Malta case, for example, it fundamentally said that the human right for property was not a human right that applied in that case, because the state had a statute called nothing other than Land Appropriations Public Purpose Ordinance, pursuant to which the state could appropriate, or more specifically, expropriate any property, if it so deemed, without any justification, so long as it explained that it was for a public purpose. This is absolutely critical that we develop some sort of objective criteria for public purpose. And with that in mind, I just want to say one thing in closing. When we first started lecturing on this book, a very, very renowned commentator and academic, Harold Coe, the former dean of Yale Law School, head of the legal department for the State Department under Secretary Clinton, So you guys started that book with a quote from Immanuel Kant's Perpetual Peace. And you ended up really sounding like Hobbes. Power and despair, and there's absolutely nothing to do. And with all due respect to Professor Coe, we didn't. We ended up citing to Ovid in the Metamorphoses, in a passage that is very moving, where Aeneas confronts a Sibyl and is asking for permission to cross the spaces of hell so that he can see his dead father's shade. And in it, the Sibyl says, Aeneas, you're a man of courage and piety, and your sword and honor has spoken for itself. And then the Sibyl says this, nulla via in via virtuti est. For virtue, no path is impossible. You will be allowed to see your father's shade. And what we're saying in the book is, the journey may be long and tough and difficult to arrive at a consensus for public purpose or to arrive at an objective standard. But if we try, and if our motives are precisely bringing transparency and justice, virtue will prevail. And I thank you for your patience.
Thank you very much for this comprehensive presentation. I know that we could go for hours, but unfortunately our time is running out. However, we still have around 10 minutes for Q&A. If there are any questions, please.
So we talked about international public purpose, but I was wondering how domestic public purpose enters the conversation. So U.S. like eminent domain. So is there any bearing on international stuff?
Yes.
I think so. I think it's you're talking about basically the Fifth Amendment's taking clause and how that may apply also in other aspects of the U.S. law. We suggest that the concepts are related but distinct. They're related because obviously the whole expropriation idea in international law looks very closely parallel to the U.S. constitutional jurisprudence on taking. On the other hand, they come from different sources of law. And the U.S. constitutional doctrine is in a very particular U.S.-centric context, whereas the international law is not. And our suggestion, for example, is that the public purpose doctrine should not be quite as broad as it's been applied by the U.S. Supreme Court in, for example, the Kelo case, where someone's home can be taken and given to a developer on the theory that, well, we're going to make the area better and the state will benefit that way. That may be a perfectly legitimate application of U.S. constitutional law. Our suggestion is that in terms of foreign investment protection, it's probably not. That pure self-enrichment is not a basis for public purpose. That there needs to be something more directed toward the public good, perhaps along the lines of the state functions identified in the NAFTA standard that Pedro suggested. But clearly there's got to be a dialogue between the two. We're talking about a doctrine that is, we hope, emerging from the historical view. Many people are going to have a lot to say about it if the doctrine is to move forward, and part of it will, I'm sure, be looking to the U.S. constitutional laws. It's a great question. Thank you.
Following up on that, are there any instances in which you guys in your research, I guess, have seen a disparity between the articulation of public purpose in the international context and domestic case law or domestic law surrounding the notion of taking? And if you have, do you have like an optimal resolution to that sort of thing? So like if say domestic law is narrower than international, or the standard that you guys articulate for international law, should domestic law pervade? Should the government be prevented from making an argument that would be sound under international law if it's not internally sound? Does that make sense?
Sure. The area that comes to mind for me, and Pedro may have an extra perspective on it, are the foreign investment protection statutes that we've mentioned briefly. And basically, for those people who aren't familiar with them, a number of governments, in an effort to attract foreign investment, will pass their own laws. They're not necessarily entering into the treaty. They just pass a law that says, well, they can say a lot of things. Some of them say, we're a great country, come here and invest under our laws, and you'll be happy, which is not very reassuring to most investors. Others, they'll offer very strong investment protections. And a couple of them, they are not from countries that I can recall at the moment, but a couple of them refer to the taking of real property, real estate, for a public purpose and what an appropriate public purpose is. And in those instances, that it is a narrower definition, far narrower than in the U.S. Constitutional context, but also narrower than I think the general understanding of public purposes. They can do a lot of things in its exercise of regulatory sovereignty. And these lists are maybe a bit narrow. So how do we reconcile them? I think the way to reconcile them, there's several things. But first of all, recognizing that they're from different sources of law. If you have a state national law that applies a very strict definition of public purpose in one context, well then that state's law should apply. And if the state has committed itself to compensating landowners very aggressively and let's say fairly or generously, that's great. That's a matter of the state's domestic law. If the international law legal standard is more generous, more tolerant of state action, then the claim is one under domestic law, and it may not succeed under international law. That being said, though, I think there is a dialogue between the two. We talk about foreign investment protection statutes in general as being some form of evidence of what states mean when they enter into treaties promising to take certain steps, including expropriate only for a public purpose. And so to the extent that we can derive an understanding of the state's meaning by looking to their domestic laws, that can be helpful in trying to arrive at a common understanding of public purpose.
That's an excellent question. Just following up on Ryan, understand this. Many industrialized states have multiple bilateral investment treaties that they execute. Yet if you look at these states, they have foreign investment protection statutes, or FIPS, that have definitions of public purpose and have standards for public purpose. You really have three types of these statutes. You have statutes that fundamentally protect against expropriation and say we will not expropriate under any analysis. And a statute that comes to mind, for example, is the Egyptian statute. There's a statute very close to that, which close but not altogether identical, which is the Vietnam statute and the Kuwait statutes. The foreign investment protection statutes are very, very pro-investor, but they do carve out a space for public purpose. You have a second universe of statutes that fundamentally provide for compensation and deals if you invest in it. But then you have the final type of statute where it just says, we're a good country, come here and obey the laws. Most of these statutes are at odds with the bilateral investment treaties because, of course, the bilateral investment treaties are the product of negotiations. And the states somehow are not consistent in what they're saying internally and what they're saying externally. So this is one source this is one dichotomy that we find. We also find that these statutes are a great vehicle for moving forward towards a uniform standard.
Is there any difference for the justifications of, or I guess when you're treating takings from a real person versus a legal person? So when they talk about takings or justifying for public purpose, will the governments use different language when it's a natural person versus a legal corporation?
No. First of all, I understand the way you're doing it, but you're drawing a distinction between natural persons and juridical entities, legal entities. for purposes of this framework, they're one and the same. They're both equally legitimate.
First of all, thank you very much for your speech. And my question is that we often hear the cliche that the value and interest across the country are more heterogeneous than the value and interest within one nation state. Will this situation create more problems in interpreting the terms of public purpose, or the situation is a little bit exaggerated? And the second question is related with the first one. Is the current methodology interpreting treaties, say the VCLT, if appropriately applied, which ameliorates the current situation? Thank you.
Let me take the second question first. The Vienna Convention is not helpful in this regard because there is no attempt by these states to formulate a definition of public purpose. It's in their best interest. That's why we're trying to talk about human rights together with public purpose. Human rights, of course, narrows the scope of the state's regulatory activity. Public purpose broadens that scope. That scope can only be broadened if the doctrine is not defined or defined as little as possible. So that the convention, placing its emphasis, of course, on plain meaning analysis, doesn't really get us to where we want to be. Again, because it buys into the fundamental premise of the way in which the challenge is posed, namely, public purpose being defined as self-judging, non-consequential, preclusive, all or nothing, non-proportionality, whatever the state says.
Which I think treats the paradox that we talked about earlier. If we have public purpose that is infinite in meaning, then the consequences of public purpose, one of which is reflected in language and the very same instruments, never come into play. And so we run into a paradox in trying to apply the BCLT approach generally. Your first question, could you elaborate just a little on that more?
Say that you only, I noticed that you only mentioned that the original meaning of the doctrine of public purpose that is originated from Greece. Say that probably that in ancient China it has its own version of public purpose. Will that create more problem or chaos for this current situation?
I think it's fair to say that we did not look as closely at ancient Asian history, and so that may be an interesting thing. In terms of the sources of information that led us to the modern day, the sources that are available to us haven't led us back there. But I think if there were, what we haven't seen are suggestions of different views of a historical doctrine of public purpose. If there had been, maybe this discussion would have happened a lot earlier among treaty negotiators, rather than a couple of lawyers in a classroom trying to say we need to give some meaning to this concept that is different from simply treating it as a given. But I think whether additional sources can be found with different perspectives, or whether different perspectives can be brought to bear today, it's important that there be a dialogue or a conversation among the different perspectives, and that we try to arrive at a common understanding that allows the doctrine to have some meaning other than being just simply self-true.
I think it's critical because if international law is going to redeem its promise of being international, it has to take into account what the other side of the world is thinking of something. So it's a very timely and relevant question.
I think our time is up, but I'm sure
There's going to be an evacuation.
But before leave, please join me in thanking Mr. Martinez-Fraga